no state currently is opt-in unless you're dealing with very specific kinds of data. So the banner, in a lot of cases, might just be because they set it up for Europe and they didn't geofence it properly, so they're going to show it to everybody. So if you're trying to hold on to the profiling, trying to hold back the ocean, it will eventually, at the rate it's going, that won't be a thing that you could easily do any longer. But not a lot of people are willing to go to trial because, as in the case of Sephora, where they argued every time Sephora transferred data to the third party was a violation. Well, I mean, how much traffic does your site get?
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, we have Cory Underwood with us today, and I will take the liberty to call Cory a privacy engineer with a strong marketing data technology background and a good knowledge of both US and EU ePrivacy law. Cory supports Search Discovery's data privacy offerings, leveraging 8 years of experience in privacy efforts and multiple privacy-related certifications like CIPT, so for privacy technologists from the IAPP, CIPPE, or CIPP US, if you know what those mean. You can also find Cory's in-depth analysis and some insightful updates on his blog. This is my second interview with Cory after our Google Analytics and global privacy control discussion over a year ago. We have now tackled the following questions. What does it take for digital marketers to comply with state-level privacy laws in California, Virginia, Colorado, and beyond? Will the US Internet suffer the fate of European websites annoying consumers with user-unfriendly consent pop-ups that mean little and cost millions? Why do some US websites insist on replicating the European ordeal if there are no opt-in requirements? A burning question of mine. What will be the side effects of large platforms adapting to the EU's Digital Services Act in terms of transparency and return on investment for SMEs? And also, where will Topics API, so the star framework of Chrome's privacy sandbox, fall in terms of consent requirements? I will add to that I had to control myself and cut out a few of my rumblings, as we found it very easy to go all over the place. In particular, we've put aside what Cory has called in this interview the Google Analytics 4 can of worms, referring to the no consent signals from consent mode, what in the Google world is called consent mode, and whether those signals can be processed under legitimate interest. So that's for the EU. The fact is, I had a very good chat a few weeks ago about this very issue with Jesus Martin, who is a Google executive in charge of privacy and analytics products, also a lawyer at Google Spain. And I really think it's worth parking the topic aside until I can either share key insights from that chat or maybe have a separate interview with someone else at Google in the UK or in the US. But the link to the interview in Spanish is also provided in our show notes. And AI does magic these days, so it's up to you what you do with it. And Let's go for it. Cory, thanks for coming again.
Thank you so much for having me.
Look, I'd love to understand the logic for do not sell, do not share in California and the news you have been reporting on regarding other states like Colorado, Utah, Connecticut, Virginia before, Texas now coming up. They all have an opt out for targeted advertising, right? Can you give us a quick overview?
Right. So by and large, most of them will allow you to opt out of targeted advertising. A lot of them also allow you to opt out of like profiling that may have significant effects. So for example, if you're profiling to like judge if they're financially capable of doing something, like, no, that's not, they could say, no, you can't do that. And you might actually be subject to other laws that would prevent you from doing that anyway.
Today, most people I know have been looking at California and assuming that Virginia and others were sort of replicating what California was doing. But it's not the case, and thresholds are different. Have you been forced to find the best possible way to solve or to comply with 4 or 5 different state laws with a single privacy notice?
So we have come across clients who've had that issue, right? They operate nationally. In regard to the laws themselves, there's kind of two different forks. So we have like what California and Colorado are doing, they're more strict and more prescriptive. And then you have, as an alternative to how strict California was, the legislature in Virginia stood up their version. And so we've seen states kind of go one of two ways. Either they're more closely aligned to California or they're more closely aligned to Virginia. And you are correct. All of the qualifications for if those laws apply to you are potentially different. And the exemptions are potentially different. And even the definition of what selling data is might be different between them. So that unfortunately puts clients in a difficult position where they have to either figure out, well, do I now need to have like 10 different processes depending on what state, the customer's in? Because that's what we do in the insurance industry. Or do they want to go and say, well, California is the strictest, so do we want to align to California and every other state that covers like every state, right? But it might mean that we're doing things that we don't need to do just for the sake of operational streamlining.
So, California is still the most restrictive today.
I would say in most cases, yes. There's a couple of things that they haven't done yet. So, for example, they came out with all their regulations, but those regulations haven't really defined the risk assessments or the cybersecurity requirements yet. Meanwhile, Colorado did. So, in the case of those two areas, Colorado probably has the strictest interpretation at this time. Once California gets their regulations ratified, will they be in line with Colorado or more stringent? I just don't know yet because that's still ongoing, and we probably won't know that till sometime in early 24.
So let's assume that we need to play by everything we see out there. So first the thresholds. If I understand well, there's like 100,000 people. Is that right? The primary threshold for most of these, maybe they change, but in my head it's 100,000 customers or visitors or people in the state for you to be forced to apply the do not sell, do not share.
So do not sell or share is a requirement specific to California. It's like a link in the footer. You have to have the link, or like your privacy choice. It basically is the same thing. You have to be able to have that workflow. In the other states, you just need to provide them a mechanism of opting out, and there's usually a timeline associated with how quickly you need to honor that. So it's a little bit different. California is more, we want the notice to be front and center, where the other ones have to have a method of doing that the user can easily find.
So we have that properly displayed because one, we're big enough So we have an audience and there'll be different thresholds. But two, because we are going to engage in targeted advertising. Otherwise, I understand you do not need to have a do not sell or share because there is no such thing happening, so there's no opt out possible. I guess you just say we do not engage in these practices. So is there a simple way to just simply stop doing whatever is covered and not having the prompt or in this case the link?
Yes, but only if you're actually doing the thing, right? So, for example, Sephora, when they got hit by the California Attorney General, didn't have that link. And they said, well, they weren't selling or sharing, they weren't selling data underneath the California law at the time. Unfortunately, they didn't have any of the contracts required that would identify their vendors as service providers. So underneath California law, they were considered to be selling because the contracts that said that they weren't selling weren't in place, which is why part of that settlement hit.
All right, very good. I missed that part about Sephora. Thank you. So then there'll be companies that don't want to be doing targeted advertising. Maybe they don't need it, or they do it in some other way. They don't want to be sending data across to third parties. There'll be companies that will keep doing what they're doing now, and then in California they'll need that link. And then there will be the whole global privacy control and the expectation on the consumer side or on the individual side that they can opt out in an automatic fashion instead of going through the link, and in this case doing it through the browser. Is that working? Do people do it?
Well, that has a couple of issues, right? So the global privacy control is a standard that has been adopted by the state of California as being a valid opt-out mechanism. And so when the browser transmit that signal to the website should acknowledge that and not send data onward to vendors that they don't have a service processor agreement with. With that said, not every browser has adopted that yet. So you can enable that in Firefox. Brave will transmit it, but you can't turn that feature on in Safari or Chrome currently. Secondly, it's been a requirement for the state of California since 2021, so before the CPRA amendments. And still, a very large portion of the websites that I review do not have that enabled. And that was one of the things that Sephora got hit with in their settlement, is they didn't honor that signal. So, I mean, it's improving. I think the last time I looked at, so roughly 7% more people actually honored the signal this year than they did 6 months ago. But still, as of the 500 sites that we reviewed earlier this summer, I think 87%, close to 87%, did not modify their behavior at all.
We used to do the platform for privacy preferences policies in XML, and there was again 2003, 2002, whatever, and every website had to have it in its root, the P3P XML file. So there was a common schema, and then every computer, every browser, if it was ready for it, could scan through a privacy notice and understand what was going on and easily translate it for anybody. And at the same time, it would allow you to simply, in your words, through your settings, customize your environment to then see whether a website would match your preferences. Do you see anyone building similar bridges or something along these lines to interface with global privacy control in the absence of adoption at the browser level?
I mean, there's some extensions, I believe, that will start transmitting the header or in the JavaScript property as needed. But I think we're going to see a surge in adoption because right now California is the only state to require it. But several of the states that have entered enforcement have clauses that will engage over the next several years that implement or require their own controls to be in place. So they might choose to go with the GPC because it already exists, or they might classify a different control, and the websites will then need to monitor all of those.
Okay, so I guess there's still hope for the US internet to escape the consent pop-up.
Right. So in most cases, yes. Although most of the state laws have special situations in which you still need to get explicit consent, mostly when you deal with like
Yeah.
sensitive data. Recently, the FTC sent a bunch of cease and desist letters to a bunch of tax companies because they were sending financial information to social media platforms, and that wasn't expected by people filling out their taxes. So they said, if you're going to do something that's completely counterintuitive to someone trying to do something, you need to ask explicit consent and get their sign off prior to doing it.
Which makes a lot of sense.
Yeah, but the regulators are finally starting to like really come down on that. So we'll see how that plays out over the next couple of months.
I understand that we do not have a way for the FTC to intervene unless there's that overlap, right? So children, health, financial information. Do you see any other room for the FTC to stick its nose in it?
There might be a case for educational claims that I believe they share with the Department of Education.
Very good.
But in most of the cases, the FTC requires it's like a reactive body, right? So the company has to do something, and then they have to be like, does that meet the standards that we have set out? And if not, then they can do enforcement. Um, they usually leverage their Section 5 powers, so they come after like unfair or deceptive advertising. So if you claim that you're HIPAA compliant, you might need to demonstrate that. And if you're not, that's
Oh, that's
deceptive
very good.
advertising.
That is a very good angle.
So they've actually had a series of blog posts around like AI usage where they're like, if you're going to use AI, it has to be transparent and you can't claim that like a human's creating it if it's not human made. And they go all into it and they're like, we're going to come down on people who are like, it's AI powered. Spoiler, if it's not actually AI powered, we're going to enforce against you.
So, if you sell to children, it seems like at this point your options in terms of advertising are limited to what we always had. So, closer to mass advertising, non targeted advertising. You cannot chase kids around through retargeting and so on TikTok or YouTube or whatever.
There was actually a case that's relevant to this. So, Weight Watchers is like the weight loss company, and they were caught using targeted like profiling children to do like targeted weight loss plans. And the FTC ended up enforcing against them, and they used a mechanism called algorithmic disgorgement. So, in addition to the fine and the compliance efforts that they would have to undertake, they made Weight Watchers delete the algorithm and all the training data and all the output of that model. Like, just wholesale, you can't use that anymore. Delete all of the things. And they've done that 5 times total so far. So like the FTC will go all the way through and be like, well, you got to delete everything and the mechanism that you're doing the model with and all of that. So in a lot of cases, those types of companies not only have to be cognizant of the specific things that they're including in their advertising, but the mechanisms that they deliver it through are probably more contextual than targeted because they need to be able to demonstrate that they weren't in any capacity targeting a specific group for a specific purpose.
So few industries really are going to be able to, even if you're not in any of those target demographics in terms of your customer base, you're still going to see less options in terms of targeted advertising because now the platforms have to react to these constraints and they're going to offer less and less. So they become more of a black box. And then you've got these performance max in Google where you just throw their money at them. You tell them that you want to sell, but you won't be able to choose an audience. Or you go to Facebook and they have this Meta, they have this Advantage Plus program now where you just, again, black box. Here's my money. I want to sell, I want to get leads, because they won't be able to offer me a choice as they used to in terms of granular audience choices. So it is going to have an impact down that sort of food chain. So then going away from that, if you are, and now that you've been auditing some websites, Do you see a scenario in the US as of today where you would need one of these consent banners? Because I see them for the do not sell, do not share, which in theory only require a link.
Right. So if you're collecting sensitive information and the definition of that varies by state, but is largely considered to be like sexual preference, political affiliation, and so on, then you probably need explicit consent and you would need a banner prior to the either a banner or like a notice on the form or what have you, right? To say, we're collecting your data for this purpose and so on. But by and large, no state currently is opt in unless you're dealing with very specific kinds of data. So the banner in a lot of cases might just be because they set it up for Europe and they didn't geofence it properly. So they're going to show it to everybody. And then you have like the really risk adverse companies, and their lawyers are like, everyone gets the banner because under no circumstances do we ever want to be accused of collecting something that we shouldn't be. So there's just no case law, right? So the lawyers look at the black letter law and they're like, okay, this law went into effect 3 months ago. All I got to go on is what it says. There's nothing like anything ambiguous. There's no case law to reference. So I'm going to take my best guess, and we might be more risk adverse depending on the industry, right? So it doesn't matter what lawyer you talk to when it comes to the California or the Colorado Privacy Protection Act that went in effect in July. Like everybody's got the same 3 or 4 months of experience at this point, but there's been no AG enforcement. So it's like we got what the AG's told us, and if we did it right, we're not going to get hit with anything. But until there's case law to reference and argue some of those points, the lawyer can only make their best guess. And they might reference things that have happened in other states that could show like how courts have ruled, but there hasn't been a lot of enforcement action that has gone to trial. There's been a lot of settlements, but not a lot of people are willing to go to trial because, as in the case of Sephora, where they argued every time Sephora transferred data to the third party was a violation. Well, I mean, how much traffic does your site get? And how long of a time span are we talking about? I mean, that's thousands, right? So, like, it's easier or more cost effective in a lot of cases to settle in that instance, even if the terms aren't as ideal, because if you actually went to trial and got, actual calculated damages, that could be potentially significantly more than the settlement cost.
So, one thing is the law. We have the law. We have all of these states making it very hard. Privacy notices are getting longer with so many sections and really hard to understand, to process. Then you've got all of these people, asking for some sort of consent in an opt-out scenario, which is very confusing. And then at the same time, we've got what platforms, gatekeepers, and whoever can really enforce things much, much better, reacting to the same laws or overreacting to them, and as a consequence, creating another layer. And now Apple is an example. So the latest iOS 17, we've already discussed ATT here for mobile apps and many other things. But now we've got the latest thing, which is iOS 17, this link tracking protection. How would you describe it?
Sure. So Apple has three things related to privacy in iOS 17. Link tracking protection is the one that's definitely got the most media attention. And so what that will do is in Apple Mail, Apple Messages, and in Safari when it runs in private mode, it will look at the URLs on the device that you have clicked. And in the event that it has identified one that identifies you specifically as a user, it'll just remove that from the URL. And you'll still be able to go through to the site. And so from a marketing perspective, that means that for the links like this that are affected, they might be able to tell what campaign you clicked through, but they won't be able to tell who you were.
Yeah. So it has an impact on everything we're doing. Since last time you and I spoke many months ago, we talked about Google Analytics and GA4.
I would say maybe for the Google Analytics thing. So for example, if you have consent mode, which is its whole own can of worms, you can configure the tags that Google owns to still send pings to Google just without most of the identifiers, and it will use those to model. So while that might be legal underneath the United States framework, I'm kind of the opinion, and again, this is not legal advice in any imagination, that under Europe, probably it's still not okay.
People are normally most excited about the possibilities to build a profile around the customer, and now in GA4 to download, customer profiles and so on. So the more things make progress towards modeling and privacy enhancing technologies, and more advanced statistical solutions rather than granular deterministic solutions, then the harder it is for smaller companies to understand what's happening. And the more you depend on someone else to do it. How do you see that point of view?
Very black box. So you have to figure out like how much do you trust the thing that you have no clue how it works. Uh, some companies might be very willing to trust it because they see the results. Other companies might be a little bit more skeptical. And that's something that every company is going to need to figure out on their own. But measurement in general is going to continue to get more difficult. And that's why you see Google testing their topics APIs, the rest of the privacy sandbox, and Apple's pushing their private click measurement. And they're moving away from the ability to do profiling, but still be able to measure the effectiveness of the advertising. So if you're trying to like hold on to the profiling, trying to like hold back the ocean, it will eventually, at the rate it's going, that won't be a thing that you could easily do any longer.
Yeah, so the way the tide is going, as you said, yes, it all seems to be going towards the black box. So there was a time when we had small clients, small companies, SMEs, small consultancies. The world was again deterministic. You would run a campaign, throw it at a small number of people, and you would see how it performed or would it perform better because you could identify the company, even the person. Again, there were no constraints in terms of privacy. The more we apply safeguards, then the less we can see deterministic data, the more sophisticated it becomes to analyze campaigns, the more we depend on people that are able to do it. Now Meta are able to take the SDK ad network signals from Apple in the app world and extend the attribution window in a manner that few people dare, because they have such powerful models now and such media mix models. They're even open source in some of the models, this Robin and in the Meta world, and Google has their own. So they're going very far and very sophisticated, which means that, as you say, smaller players are going to find it harder in this world. You need to be much stronger in terms of advanced statistics and mathematics, or else depend on someone else. So if you keep pulling from that thread, where do we end up in terms of analytics? It seems like you've got a few tiers, right? But please correct me.
Yeah, you have different tiers. Now, the one thing that I am very curious about is the FTC is filing all these antitrust investigations against like the media companies. So they currently have one for against Google for search because they claim that search has a monopoly. And I mean, depending on whatever the corrective action for that could be, is they might have to spin off search, right? So that could be something that happens. And then they're also suing Amazon over their marketplace. And I don't think they're going to stop with those two. So you have to question the mechanisms that allowed these companies to get so big in the first place. Are those even going to be allowed going forward, depending on how these antitrust cases go in the United States, right? But I know that a lot of these companies have faced similar antitrust investigations in Europe that are still ongoing. So, I mean, it could be that as a society, people just decide, no, maybe platforms should not have that much power.
It seems like the more privacy we have, the stronger a Meta becomes in terms of surviving all of these obstacles, because they're stronger and they have all of these, bright people, and they can offer,
More
yeah, more
resources.
resources to deal with complexity.
It's like that for a lot of things when it comes to privacy. Like your legal team how many hundreds of pages of laws are they going to want to read, right? Like if the United States enters a situation where we're currently at 12 in the next 3 years, are we going to get up to like 20 something before we get a federal privacy law? Like, how far is that going to go? And then how is your how does that scale internally within your organization? Like, you can't fork the code base necessarily, and so that's why when the DSA came out, Apple's like, oh well, we'll make those changes, and they're going to be global. And then Facebook came out and said, we're going to do it too, Europe only. So some companies want to push their luck, or other companies are just like, it's not worth the continued fighting because it's opportunity cost, right? Like the more that you fight stuff, like you can't move forward because it doesn't make sense to build something that you're gonna have to
Yeah,
tear
that's the
down.
thing. So it's like now you have all of these layers. So you've got the platforms that, yes, they can have their own version of the law, and then they start applying things like, as you were describing, Apple's, Google's, Topics API, another story, maybe for the end. And then you've got all of these large companies that can survive the platforms because, again, they have such muscle and volume and engineers and mathematicians and so on. Then you've got large companies like large brands that have traditionally had the resources like a P&G that won't play ball with whichever metrics Meta is throwing at them, but they don't seem to have much leverage in this scenario. They will have bigger teams. They will not trust Google Analytics. They will not trust the black box in Advantage Plus. But in the end, they're at the mercy of all of these, of both scenarios. They're at the mercy of the platforms because they need to now go around these restrictions for UTM variables and whatnot in terms of measurement. They're at the mercy of all of the state laws. And a good example is looking at the Disney.com privacy policy and how wild it goes into all of these state laws. And then you've got smaller companies that really want to sell. They want to go and just, do their thing and survive. And they need to put money somewhere. The open ecosystem is becoming even more complex because there's a lot of intermediation. So there's a lot of data selling. And through intermediation, consent becomes harder to gather, of course, as well. So the easiest, simplest thing is to throw more money at Meta and Google. So there you have another constraint. But let me finish because then, if not, I'm rumbling, asking you about Topics API. And I promise the last thing I'll ask you. Topics API, I was hoping all of this time that it was not going to require consent. The CNIL in France, the supervisory authority in France, has already said it will because it writes to the local system. Therefore, it falls under, the French version of the Article 5.3 of the Privacy Directive. So you need consent, like cookies. So basically, it's similar to the cookie scenario. Where do you see Topics API falling in terms of privacy compliance?
In Europe, I definitely think France's interpretation is going to be correct because the browser constructs the model and then you need permission to read it, right? So I don't think that, I think ePrivacy directive is going to take precedence. Now, I don't know if because they're aggregated and there's like a 20% chance there could be categories in there that don't actually correlate with that user. I don't know if that's going to be sensitive enough for GDPR to apply because like I don't really think it's identifiable if it's that. On its own, it's not, right? But like if you start combining with other stuff, potentially. On the United States side, though, you can opt out of targeted advertising. So the question then becomes for the United States regulators is getting a list of the categories you're interested in targeted, right? Because you're not necessarily using the context of the website you're on, you're using the context of where they've been previously, which might be different from the context of where they are now. So it very well could be the topics ultimately gets ruled targeted advertising because the context could be different and you not so like it might I've got to be looking at like movies and it might say, hey, you want to buy sneakers? That's not relevant to my movie selection. Not like you want to sell me popcorn or something? Okay, that makes sense. But like Where'd you get the sneakers from? Was it because I was looking at shoes last week? Well, then that's targeted, right? Because like you wouldn't just share that to anybody. So like, yes, I'm in a cohort. Yes, you don't know who I am, but it's still targeted, in my opinion. So it's going to come down to, do the regulators see it that way? And if so, you'll need to be allowed to opt out of that.
And hence the problem starts again.
Yeah. It turns out when you want to opt out of targeted advertising, coming up with a separate way of doing that same thing doesn't actually help you.
True. Cory, thank you very much. It's been a pleasure.
Always happy to chat with you. Love the conversation.
Thank you. Okay, that's all for today. And you will find some episode notes and links to our social channels on mastersofprivacy.com. Thank you for listening.